Hey everyone, sorry I'm late. I was excused, but it's always a good one. So this time, do you know how there's some things where you always buy name brand? Like they say generic's just as good on most things, but there's one or two things where you need a name brand. I don't have very many because I'm cheap, but I just added something to the list, and that's bottled water. Because I always buy the same bottled water, but the price went up. So I went to the cheap store brand, and I swear it's like in a Ziploc bag. The plastic is so thin. I take the lid off every time and it explodes all over me. So I went to take a drink of water right as I was about to go live and got soaked in half a bottle of water. I guess that way you waste half of it and you have to buy more. I don't know. I totally didn't set up the cat thing. Like, he's posing on his own. I didn't orchestrate this. That's all drama for you guys. So I found an update on Mr. Oregon, which some of you may know, some of you may not. And I was trying to figure out how to summarize what had happened up to this point. And I hardly remember because it's been almost a year. So I decided, let's just rewatch the whole thing because he's still arguing it's not my fault. He's such a baby. So let's just rewatch and enjoy and have a nice relaxing Sunday afternoon watching someone whine and cry and be a baby while my dogs act like babies. Here we go. Okay, to set the stage, Mr. and Mrs. got divorced sometime prior to this, but in December of 2022, the guardian ad litem was appointed. And then early January 2023, Mr. Oregon had his visitation suspended. February 1st of 2023, the GAL had a compliance hearing. I don't have those hearings, but this is the next hearing coming up right after this. And I do have all that stuff. Well, play. How freaking long is this thing?
And I think Mr. Lawrence is the GAL in that case. I know Mr. Gilbert is in the booth at the courthouse. And Aaron Gilbert's here. Let me get to my notes.
Mr. Lawrence in the top is the guardian ad litem.
Last time we were here, I required a 12-panel hair follicle test by Mr. Gilbert and a substance abuse evaluation. I didn't see anything in the file. Mr. Lawrence, are you aware if those have been completed?
I have not seen anything, Your Honor, and I checked Odyssey on Friday afternoon and didn't see anything either.
Mr. Gilbert, have you accomplished
that was on the internet? And it clearly states it was Portland, Oregon. Measure 110's effect February 1st of 2021, which decriminalized possession of cocaine, heroin, methamphetamine, oxy. So I don't understand what a hair follicle sample is going to prove anyways.
So after watching all of this and understanding it all the way up to the current point, he is remarried and there's lots of issues with his new wife, or I guess she was a girlfriend at the time. I don't know. Anyways, there was an accusation. She made an accusation against him for drug use. So Erin, the ex-wife, took him to try and get his custody taken away. So the judge is ordering a hair follicle test, excuse me, because of that. That's kind of where we are. I apologize for not setting that up better.
So we're here because your current wife filed a declaration in a protection order case,
Thank you.
alleging concerns about drug use, about domestic violence, and domestic violence involving your son. That's why visitation is suspended at this time. And we're not going to be able to move forward until you get both the substance abuse evaluation and the hair follicle. And if it shows that nothing's going on now, I will be happy to reinstitute visitation, but I need objective evidence that that's the case.
I can't afford it, Your Honor. And by what she was stating, it was stated in the state of Oregon. If you look at where she stated it, it was the state of Oregon, which Measure 110 is in effect February 1st of 2021. So it wouldn't matter if I did it in the state of Oregon.
All right. Well, I'm sure you're aware of the declaration that I see, which has been recent. That is.
What are you looking at?
Mr. Lawrence, have you had any contact with the parties since our last meeting?
No, I have not, Your Honor. I was awaiting the results of the hair follicle and the substance abuse evaluation. I did have an email communication with Mr. Gilbert's wife, wanting to know how she could get these evaluations and hair follicle exams obtained. And I gave her some information on that. And that was my last communication.
All right.
I
Ms.
can't afford it, Your Honor. With child support, everything else missing work, I can't afford to do it. So what am I being sentenced for?
Ms. Gilbert, any comment?
I mean, I'm sure he can afford it. So I don't know. I don't know what to do.
Sir, I'm still going to require the test and the evaluation. And I'm going to put this over a month, and hopefully you're going to be able to find the funds in that time.
So if not, how long is my visitation suspended for? What's my charges and what's
It's not going to start. It's not going to start until you do these two things, which is do a substance abuse evaluation and a 12-panel hair follicle test.
So I'm missing work and everything else, and it wouldn't matter if it comes back positive or negative if it states that I was in the state of Oregon. How are you going to know what state I was in if I was doing it?
You're not being charged with anything.
I'm not being charged with anything. Yes, I am. I've lost the visitation of my kid. I've had to pay the license.
You dumbass.
Target on my back.
All right. So my ruling stands. You need to complete those two, the substance abuse evaluation, the 12-panel hair follicle test, or we consider additional visitation. And I'm going to put this over to March 22nd at 9
So
o'clock.
I'm not being charged with nothing?
No, not here. It just, I'm suspending your visitation because of the concerns that were raised in the declaration that was filed in the protection order case.
In the state of Oregon.
That declaration was filed in a Washington case.
But it clearly states on Facebook and everything else that it was in use. She put drug use in the state of Oregon.
Okay, I know there's a little bit of a connection issue, but does anybody else feel like they're talking in slow motion? I just want to like wind them up and say, go faster. So to answer the question, is this about weed or other drugs? So just in, his wife posted something on Facebook about him using drugs, but she said it happened when they were in the state of Oregon. Oregon passed a measure, ballot measure 110, or the Drug Addiction Treatment and Recovery Act. And basically the purpose of that is to kind of reroute the people who were getting minor drug convictions from going straight to jail and get them into a treatment program to rehabilitate them. And so he's taking that and saying, no, this ballot measure means drugs are legal, so you can't drug test me. And he's mentioning meth and cocaine and everything else. So I don't know what drug he was accused of using, but he says meth multiple times.
Domestic violence in the state of Washington.
About that. So I made my ruling. Thank you.
Thank you.
We'll see you back here on March 22nd. I know Mr. Gilbert's here in the courthouse. Mr. Lawrence is here. And
I'm
Ms.
here.
Gilbert is in her car. Last time we were here, I reiterated the requirement for the 12-panel hair follicle test and a substance abuse evaluation. Have either of those been done, Mr. Gilbert?
No, I said I couldn't afford it.
All right. Mr. Lawrence, have you been able to look into this case?
All I've done, Your Honor, is my initial investigation in this, and I checked yesterday to see if any documents had been filed, and there were none. I guess my suggestion at this point is that we simply leave status quo in place until Mr. Gilbert decides to comply with the court's orders, and then he can petition to have it reviewed.
That was one of my thoughts. Ms. Gilbert, when these issues first came up, you asked the court for an order of adequate cause so you could potentially make a permanent change in the parenting plan. Would you still want to do that, or there's also Mr. Lawrence's thought that we just leave this until Mr. Mr. Gilbert gets the test and does the evaluation.
Yeah, I mean, I guess if we could leave it and give him more time, I guess. Yeah, I'm not sure what the best thing is, but if he did do it, then that would be best. Sorry. So yeah, I don't know if we can leave it for a while and see if he does something before making it permanent.
Ms. Gilbert, what would you think of having at least telephone contact between Mr. Gilbert and Max at this point?
Oh yeah, I mean, I believe they do. Yes.
They do already?
Yeah. I mean,
Oh.
I believe so. Yeah.
Okay.
How long is Max can be punished and kept away from his grandparents and stuff? Over hearsay on the internet.
He never sees his grandparents that side anyway, but
Mr. Gilbert, I
Else with
just want to remind you, it's more than hearsay. We have a sworn statement by your current wife that has raised these issues. So
police reports say different.
okay. Mr. Gilbert, are you in telephone contact?
He's always the victim.
With Max at this point?
Yes, I've talked to him a few times. Yeah.
Okay. Sir, I'm going to allow the telephone contact to continue.
What about his games and stuff?
Well, at this point, I'm not going to allow you to see Max until you get the hair follicle test and get the substance abuse evaluation.
It's almost like he's using the soft set mentality, like the argue and fight and throw all this stuff out there to get what he wants because he doesn't want to take this test. So watch how long he puts off this test. We started in February, early February, now we're in March.
And I'm going to take Mr. Lawrence's suggestion, and I'm not going to set another review hearing. When those two things are completed and I can see the result, then you can put this back on the calendar for the court so I can look at it and I can determine what a safe visitation plan will be. But until I get those tests, I can't determine that.
So when they come up all negative, how can you take away all the priceless time I've missed out and everything else?
Well, that might be something I take into consideration.
You could have had it done by now.
But I need to see negative tests before I can even consider that.
You'll never be able to make up priceless time I've missed with him.
Then you should have made it happen.
Well, sir, I've had this order in effect since February 2nd.
I can bring my bank statements down and showing you I ain't got no money. Work right now is really slow.
All right. So what we're going to do today then is I'm not making any other decisions. I'm leaving the orders for the tests and the evaluation in place. And when they're completed, Mr. Gilbert can put this back on the trial calendar or on the court's calendar. Okay.
Thank you, Your Honor.
That's it
Thank
for
you.
today. Thank you.
Okay, so after that hearing was done, they had 3 follow-up hearings that I didn't get because I figured he went and got the test. The test was less than $150. I think the hair follicle test, 150, 160 in most places, but I looked up his area specifically. I think it was like 165 was the most. So here's 3 hearings that he could have gone and got the test done and had time with his son, but during those hearings, nothing got taken care of. And then we come back and we are, oops, what's the next? We are at 6:14.
I need to let a couple
And he still
people in here.
has not submitted.
Mr. Gilbert, I gave you a week to file documents demonstrating your clean UAs and your evaluations. I received nothing.
You should have received them. I dropped them off here.
When?
They were dropped off yesterday. Everything was dropped off here.
Just
This is
hang on a
civil,
minute. I'm
so
going to check another database to see if it's in process. If you drop something off the day before the hearing, it doesn't get scanned and put into the system.
he wouldn't, there would be no charges if it came up positive. It would
But
prolong his
this other database will tell me
visitation
whether it actually is
issues.
filed. So just give me a moment, okay?
All right.
Shh.
If only done to you, you can inform the court.
Ms. Gilbert, did you receive anything from Mr. Gilbert?
No.
Did you provide it to Ms. Gilbert?
I didn't have time to get it up there. No.
Why didn't he have time? He said work's been slow. What's he doing? That's more important than reestablishing visitation with his son, who he has seen in 4 months, I think. Oh, sorry, was I muted? He's in his 40s. Sorry, I forgot. There was like a bunch of blah blah time while he's searching around trying to find his he's trying to find the papers that he said he dropped off. So he's looking everywhere for it. He didn't drop them off to the wife, so I'm really not, or the GAL, so I'm really not sure why it matters, because you're not supposed to be able to do that. You have to drop them off to both. So I'm going to guess he didn't drop them off at all. But Commissioner Nelson likes to, look around and figure it out and talk about it. But this case really got to me because it was one of those, if you really want something, you make it happen. Because over the course of 4 months, you couldn't save up $150, 4 months.
All right, just received a bench copy in this case. All right, just hang on.
I put the pup cam up, which I'm going to fix as soon as I get a chance. And they lay down and go to sleep. I don't have the pup cam on. They're running around crazy circles, fighting, playing. This one's asleep. You sleeping? Okay, come on, Commissioner Nelson. I don't want to skip ahead because I'm scared I'll skip too far. Okay, there we go.
Drug evaluation place, and they said that there was no release. Well, they didn't believe there was a release, so they couldn't talk to me about it. So I haven't got any of that information.
Mr. Lawrence, any comment?
Yes, Your Honor. Your Honor had ordered that it undergo a substance abuse evaluation with the input from Ms. Wilbanks. We keep coming back and coming back and coming back. At the last hearing, Mr. Gilbert indicated that he had the results of an evaluation and that he would file it that day. And he did not. I'm frustrated that he just won't provide the substance abuse evaluation. By his own admission in his declaration that he used meth in Oregon and couldn't understand why the state of Washington could be concerned about it being legal in Oregon. So there is definitely a problem here, and an evaluation without the input from Ms. Wilbanks is going to be worthless. Self-reporting does not work in drug and alcohol situations. My suggestion to the court is that we simply stop having these hearings until Mr. Gilbert obtains that evaluation with Ms. Wilbanks' input and files it with the court, and then he reschedules the hearing. Otherwise, we don't proceed.
All right, thank you. Mr. Gilbert, any response?
Yeah, I talked to the place Monday. They've got Keith Lawrence's email address. They've got her email address and everything there. Everything should have been released to their emails.
Who did you talk to on Monday?
I don't know the lady, the evaluation place that I did down in Chehalis. I ain't got my
You
wallet.
don't know the name of the evaluation place?
Not right off. It was on the receipt. Told you the name of it last time we were in.
Have your email
But
address.
it all done, everything else and stuff. And
The problem isn't just having the email address. He can provide the email address, but he has to physically sign a release of information, because even a hair follicle test, that's a medical procedure, and you have to sign something to release your medical records to anyone else, even your spouse. So if you sign that release for them, just giving them the email address is going to do absolutely nothing for him. So that's part of the problem. He keeps arguing, oh, they have that. Well, she tried to call and get the records, and they said, we don't have a release on file. So with no release, it's not going to do anything.
with this going on, when I was ordered to do the hair follicle test, Keith came back and said that if anything showed up besides pot, because pot's legal in the state of Washington, I claimed everything's legal in the state of Oregon. I never ever claimed I've ever did meth. I do not do meth. You've got the UAs there. If this is going to continue on, I would like, I know he's going to get mad about it. I like to subpoena Merrill in. He's our HR guy, our representative. He can come in here. He can explain to you how the fuel cards, they track the mileage, they track the fuel every day when we get fuel and stuff. We don't fill out paper tickets anymore. All of the tickets and stuff that we fill out, they have GPS location on it, coordination, everything else. It gives dates, times, and stuff. There's no way I'm joyriding a crew bus in Portland. There's no way that I came in here and did that. I mean, right now, I'm the most popular guy in the company. Everybody watches these Zoom things and stuff like that. And never once have I said I did it. I do not.
Oh, and he's special. Everybody watches him on Zoom. He's popular. See, what he did do was he did make a stupid argument that was actually incorrect on top of everything else to try and say that those drugs were legal. No, they're not legal. They're decriminalized. There's a difference. So, and that is in a criminal court and has absolutely nothing to do with a civil court. And these proceedings, he was specifically ordered to get the drug test. There's no argument that he can make about the legality of the substance that is going to really weigh in here until after he tests positive for it. And then you make that argument. But you can't say, oh, well, I'm not going to go get it because of that. And now that argument that he was trying to make just to be an asshat is biting him in the ass.
Do meth. It is legal in the state of Oregon, just like prostitution's legal in Nevada. I do not do it. And I mean, what happened? Innocent
Then take the test.
Proven guilty or slander, defamation of character. Because if you go through all these court hearings and stuff, never once did I ever admit to doing meth. I do not do it. I don't even have pot in my system, and it's legal in the state of Washington. I don't do drugs.
But there has been 8 court hearings, 6 since he was ordered to, that he has attended, been told to take this test, and has not taken the test.
So if this continues on, can we subpoena Merrill or our HR guy, like I said, I got a huge target painted on my back through all this stuff.
Then take the test.
They're questioning
Bring
how
in the
much work
results.
I've been missing coming in here all the time.
Everybody else's fault but you.
Any response, Ms.
Bye,
Gilbert,
Alicia.
before I make a decision?
I mean, just that he's had, 6-7 months now to produce any sort of anything that would show that he, hasn't been doing this. It took him, 6 months to get one clean test. So anyways, I just really am hoping to continue on to get the drug evaluation and to hopefully continue with drug testing maybe. And that's about it.
All right. I ordered some time ago a substance abuse evaluation. I believe last week, Mr. Gilbert indicated he would get that filed along with some other tests. And I do recall, as Mr. Lawrence does, that was going to get filed the next day. It got filed yesterday, but without the substance abuse evaluation and without any input from Ms. Gilbert. I agree with Mr. Lawrence that setting additional hearings at this point is really not going to be productive. I tried to give Mr. Gilbert every opportunity to get the information before me so I can make some changes in where we're at with the visitation.
He won't do any of it. He doesn't want to pay for it.
Don't have all the information I need. So we're going to leave this hearing. I'm not going to set a follow-up hearing when a substance abuse evaluation is done, when Ms. Gilbert has input into that evaluation, when that evaluation is filed with the court, then Mr. Gilbert can note this on for an additional hearing, and I'll consider changing the visitation at that time. Until we get there, I'm going to leave the supervised visits in place that we have right now. I'm not going to strike visitation. I think if Mr. Gilbert can do supervised visits through reconnecting families, then I want that to occur.
So, Your Honor, they've got their email address. How does this stuff usually get filed? I talked to them the other day and I gave them both of their email address. The counselors down there said they get the copies of everything.
Well, typically they would give you the report, I believe, and you would bring it to the clerk's office and file it. And if they haven't reached out to Ms. Gilbert, call them and ask them why and make sure that they do. And if you've done the evaluation and all they need to do is talk to Ms. Gilbert, you may be able to get us back here in a couple weeks. But right now, I'm going to put the burden on you to get that filed and then set up another hearing. Okay. All right.
So
Thank
when you feel like
you.
saying it again, go get it done. I mean, that's reasonable.
Public iPad area.
Yes.
So now we went
Okay,
from July to
great. And then do I have Aaron?
August. And this is when the new judge takes over, who really doesn't know a lot about the case in general.
Gilbert?
Yes.
Okay. And then I have Mr. Lawrence on this case. Good morning.
Morning.
All right, let me pull up your digital file. And I did get a draft order on this. What I understand is that this was placed on today's docket by Mr. Gilbert for an adequate cause determination. Respondent let's see. Excuse me, Ms. Gilbert, you are requesting the change in the parenting plan, correct?
Well, so I guess this started. Yes. I mean, this all started with a restraining order and then I guess a change in the parenting plans. So John hasn't had visitation until he completed what he has now completed.
Mm-hmm. And I'm just looking back at the prior judicial officer's orders that are in effect. So Mr. Gilbert, fill me in on why you have noted this up on today's docket. It looks like you're asking the court to deny adequate cause to change a parenting plan.
I want the parenting plan to stay exactly the same as it is. I want my visitation rights back. I did the drug evaluation. I did the hair test. I did everything came back negative. The evaluation, there's no recommendations, no nothing. I do not do drugs. I don't do any of that. I just want my visitation rights restored back exactly how they were.
She doesn't seem to have the notes about how obstinate
So what I'm
and
having
difficult he
trouble
was up
seeing,
until this point.
and I will acknowledge, especially given that your docket starts with the number 18, that you folks have been involved in this case for a very, very long time. You've had other judicial officers in this case. I am stepping in once many, many years have gone by. I'm just, and I'll probably turn to Mr. Lawrence next. I think my concern is exactly what has been filed in front of me today appears to just be Mr. Gilbert asking me to find that there's no adequate cause to change a parenting plan, but I'm not really sure that's in my purview at the moment. So typically what would happen is the person wanting to change the parenting plan would file a motion asking for me to find adequate cause to do so, and then the opposing party would object. And it looks like we might be doing this a little bit in reverse.
The state, they run out of money.
Mr. Lawrence, help me out here.
Yes, Your Honor. The action that we're currently in court for was the result of Ms. Winkles being supplied with, I believe, a Facebook post by Brenda Gilbert, and that is John's current wife. And she was alleging that John was using drugs, that they got involved in a domestic violence dispute, and so this was supplied to Aaron, who became very concerned about what was going on when Max goes to visit.
Rightfully
And
so.
so Aaron filed for a modification of the parenting plan. And the issue that the court was trying to deal with was to get Mr. Gilbert to undergo a substance abuse evaluation with the input of myself and Ms. Wilbanks. Mr. Gilbert contended that he had done that evaluation, but we had no proof of it. It was not filed with the court, and I had not received a copy of it, and I believe neither had Ms. Wilbanks. So we essentially put it on Mr. Gilbert's shoulders that if and when he completes the evaluation, then we would reschedule this matter and address it then. Mr. Gilbert did file that evaluation.
Oh my
It did
God.
indicate that they were not recommending treatment. And so that's pretty much where we're at right now. Ms. Wilbanks still has the motion to address, but it appears that the underlying fact pattern may not exist.
I see. And when, thank you for that. And when I go way, way back, I do see back in December of 2022, Ms. Gilbert had filed this adequate cause motion, and it looks like the judicial officer at that time essentially just kind of kept reserving on it pending the outcome of some of these evaluations. Does that sound correct?
Yeah. Yes.
Okay. And then there was a restraining order put in place at one time. Is that also accurate? Temporary restraining order.
Yes,
temporary.
yeah.
If both parties agree just to go back to the normal visitations, can we just do that? I mean, all the evaluation paperwork, the drug test, the hair test, everything's came back negative.
So I was just, served this or, got it in the mail over the weekend. So I did not have time to respond. I was considering asking for like a continuation just because all of this is done, but I have still heard that things are not going great at his house. They're still fighting. His wife just got a DUI. I mean, things are not going great over there still. So that's where I am.
Yeah.
I wanted to do a possible ask for more just so I could get maybe police records to see if any more action has been happening at their house for the last few months.
And when did you say you received this motion, ma'am?
Just in the mail over the weekend, and I didn't get it until Sunday, but yeah.
Okay. Mr. Gilbert, when did you mail out this motion?
It should have been right after I got it, like on a Wednesday or so.
Okay.
Could have had it for a few days in our mailbox.
You think you mailed it this past Wednesday?
Like 2 weeks ago on Wednesday.
Oh, 2 weeks ago on Wednesday. Okay, well, she's telling me she got it this weekend. What I would like to do, I better understand the posture of this lengthy case. I think that we should actually set this for the show cause hearing.
I think I can fix the audio when this
will
one's
be
done.
both based on Ms. Gilbert's original December 2022 motion, where the judicial officer simply reserved ruling on many months. This will also include, sir, your motion to ask this court not to find adequate cause. I take at face value that Ms. Gilbert says she was just served this weekend. That wouldn't be adequate time to proceed today. What I'd like to present.
Okay, she reschedules it for a week. She doesn't really say anything else that's really that important. So we're going to take this one off the screen and add this one on the screen, which is a week later, and see if we can get this audio a little bit better. Oh, wait, did I do that thing where I forgot to share it with audio? Shit, I always do that. Before Atari and Commodore, there were multiple versions of the Commodore, by the way. It was a lot of handheld games, and there was some really weird named ones. And if you guys remind me when I am not in the middle of a stream, I have tons of pictures of stuff like that because my uncle had a massive collection. Is it good? Oh, it died into the screen.
Me that Ms. Gilbert
Can you hear it now?
wanted some additional time to respond. And
Yes.
I have received on August 7th some additional filing from you, Ms. Gilbert.
Yes, which I just realized I didn't give to Keith, but yes.
That you didn't, give that information to the guardian ad litem?
Yeah.
Okay. So hold on, I'm just working with
Dog hair everywhere. So fun fact, since you're talking about video
Okay.
games, did you know
So
they made
let me just
porn
start with
games for
Mr.
Atari?
Lawrence. It sounds like there was additional filing
Who does that?
from Ms. Gilbert that you may not have in support of the motion to change a parenting plan.
I have not seen those, Your Honor.
Okay.
Sorry.
And it looks like it's, probably relevant information for the guardian ad litem by way of police reports, which my gut instinct tells me are probably a big basis for you bringing this motion. Is that correct to say?
Correct.
Okay. So what I'd like to do, unless Mr. Lawrence wants to move forward anyway, but my preference would be for just to set this out 1 week and have you get that information to Mr. Lawrence so that the court is able to have his input before making a decision on this.
Can I object to that, Your Honor? I can't miss work every week to continue on. I'm going to lose my job. I'm currently paid up on all my child support, everything else. Can we?
Poor baby.
I did everything the courts asked. The drug test, all the samples, everything came back negative.
Go ahead, ma'am.
I mean,
I
sorry.
heard you, Mr. Gilbert. I heard you, Mr. Gilbert. I'll hear from the other parties and then I'll make a decision.
I mean, I did let Keith know that I had found out that that Brenda was arrested and had her daughter, kind of taken out of the home. She just has supervised visitation too. So, and then I guess, so my next step is, wanting to get the information from Lewis County, so I can see what's going on with her case. So yeah, I don't know if you want to just do another week or if we want to wait until I actually have that information, from Lewis County.
So here's what I would say, ma'am. If this is your motion for adequate cause to change a parenting plan, but you have additional information that you plan to file in support of it, the court's inclination would be simply that we would strike today's hearing. You renote this when you're ready for the court to decide a motion on adequate cause.
Oh, okay. So after I have the information, then I would just file it and set a new court
Right.
date.
I would say bring this motion back before the court once you believe the filing is complete and you're ready to go to hearing. It sounds like the last time we met and then today there's additional information you want the court to consider.
Right. Unfortunately, yeah. Last time I didn't realize it was going to open a can of worms. So
Yeah, right. I get it. Mr. Lawrence, I guess I'll turn to you. It sounds to me like that Ms. Gilbert, the moving party, isn't necessarily prepared to move forward on her adequate cause motion today.
That's fine, Your Honor. I did review the records in Odyssey to see what I could find on Brenda Gilbert. I didn't find anything that I thought may have been an issue. And so whatever arrest she may have had isn't resolved yet. And so I think that having Ms. Wilbanks renote it once she has the information she wants us to look at would be the best course of action.
in the meantime, I did want to say, you know, John does supervised visitation, and Max, our son, is in sports and has asked if his dad can come to his games. So I don't know if that's a possibility in the meantime, if it's,
Poor
you know, I mean,
kid.
obviously I'm going to be there. So is it okay that John comes to his stuff down here? Or?
If you, ma'am, as the moving party and the one with the concerns in this case, are open to allowing him to be in person at the games, the court has no issue with that whatsoever.
Okay. Okay. Thank you.
Mr. Gilbert, what I think that we'll do then is, I'm not setting a new date. Ms. Do you still go by Gilbert, ma'am?
Yeah. Yeah.
Okay. I just want to make sure I was using the right name. I know sometimes these cases start with the married name and then change. So Ms. Gilbert, what I would ask, because there is a bench order in place that does put some restrictions on visitation, I would ask, you know, I'm not going to set a date, but please get this back in front of the court in a timely manner so that we can fully address for Mr. Gilbert what that looks like going forward. Okay.
Yes, definitely. Thank you.
But Mr. Gilbert, the court has no issue with you attending sporting events per Ms. Gilbert's request.
Okay, I'm asking the court. I was ordered to do the hair follicle test, this, that, everything else and stuff. It all comes back. I said I don't do drugs.
At the end of every stream, when they give him a chance to talk, all he does is whine about how inconvenient it's been for him. And he's done that since the beginning. And the reason it's so inconvenient for him is because he screwed around. He didn't do what he was supposed to do and everything else. And it just absolutely infuriates me because I just want to smack him and say, it's not about you. It's about your kid. It's about your kid. You could have gone, got the test. Like, what does Judge Anzalone say? Go pick up cans on the side of the road. If that's what you got to do for your kid, go do it and get it done. You could have had this done in February. Now we're in August. Shut up.
Everything's came back negative. I got no evaluations. What does the court want me to do so I get my week on, week off before summer's over? She will never be happy. She's not going to let me give visitation. I need to address the court. What am I failing at?
Mm-hmm.
I paid all my child support. Every drug test came back.
So I guess Ms. Gilbert, let me ask you this. You know, the reason the court puts changed visitation was because you filed a motion for adequate cause wanting to change the parenting plan. Are you still asking for supervised visitation versus going back to the original parenting plan?
Yes. I mean, this whole thing.
Hold on, Mr. Gilbert.
Sorry. This whole thing was not just about drugs. I mean, it was the complete chaos that is happening at their house, and it has seemed to continue. And so that's my concern. And just this morning, Mr. Gilbert texted me and said, I'm probably right, that Max probably shouldn't be there right now while he's going through this. So yeah, I mean, until I know that him and Brenda are done officially, I just feel like it's not a good environment for Max.
Okay, well then ma'am, I am gonna change my ruling somewhat because here's what's happening. You have filed a motion to change a parenting plan. The court has put some additional restrictions in place without actually making a determination on that. But you're now saying you want to present more information and you're not ready to move forward on it. But I think Mr. Gilbert has an excellent point, which is in the meantime, while you're wanting to document the file with more information that we don't have, he's losing out on time with his child.
I mean, I do have the information that, you know, his wife was just recently arrested because they got in a huge fight and he called the cops on her. That was just a month ago. So nothing has calmed down.
Okay, then what I want you to do, here's going to be my ruling. Mr. Gilbert, it is going to require you all to come back to court next Wednesday. I'm going to, rather than keeping this out, I think you make an excellent point, sir, that the court has put additional restrictions on you for a lengthy amount of time without this matter moving forward. I do think we need to have resolution to that issue. So I think that I know, I understand what you're saying about missing work, but I do think you all should come back next Wednesday at 9 a.m. Ma'am, please get that information that you filed with the court to Mr. Lawrence. And I do want to make a ruling on your request to formally change the parenting plan, okay?
Okay.
So we'll be able to make a ruling next week and find out something. I mean,
So what it'll initially be is a ruling on whether there's adequate cause to change the parenting plan. If I find adequate cause, I can put a temporary plan into place and then set you all for
Right.
trial on the permanent parenting plan. Or the court can find there isn't adequate cause to change the parenting plan.
okay, I guess summer's gonna be over. All right, thanks.
Yeah.
He
Okay.
is the one that took 6 months to get a clean drug
No.
test.
Ma'am, there's no question in front of you. Please
Yes.
get that information to
Get a
Mr.
drug
Lawrence. Mr. Lawrence, are you available next Wednesday on the 16th?
Yes, Your Honor.
Okay.
It's with the dude
I
in the top
appreciate
corner
it.
of the little peephole.
We'll see all the parties back on that date.
Thank you.
Do I have both of you present?
Yes.
Yes.
Okay,
was a
great. That's
judge
you and
and
iPad
tired
1.
of
Thank
them.
you. And I do have Mr. Lawrence on here. Give me a second just to pull up your digital file.
So I think she explained it pretty good. He had was about to get his visitation back, or he had gotten it back. I'm not sure which.
Okay.
And
So
now
when we were together last
everything
on
went down again.
August 9th, I think one of the concerns the court raised was we have this adequate
Yeah.
cause motion that's been hanging out there. There's been ruling reserved on it, but in the meantime, a judicial officer had changed, at least temporarily, visitation pending some additional information coming in. I've reviewed the evaluations or not evaluations, but the UA reports that have come in. I think that was one of the things the prior commissioner was wanting. I've looked at the documents from the original show cause motion. I haven't, Ms. Gilbert, received any additional information. I think when we were together last, you were maybe going to supply some additional information to support your request for adequate cause finding.
Yes.
I haven't seen that. So first, I'm going to turn it over to you, then Mr. Gilbert, and then I'm going to get input from Mr. Lawrence. So
Okay.
go ahead, ma'am. Where are you at with evidence and your request to change the parenting plan?
I did file paperwork on Friday. So I received, a notification that John's wife had her daughter, taken away or lost custody. And so I got that information and filed it with a declaration on Friday, just with some other stuff, a text from John saying that he agreed that his house is not a good place for Max. And a declaration from his stepson about John's behavior.
Okay. So I'll tell you, unless you provided a bench copy, which is a second copy for the clerk to give to me, there's absolutely no way I would receive your documents if you dropped them off Friday. So they're not in our digital system either. We have nothing scanned in since August.
I don't know what that means. I have to request specially for it to go to you?
No, it just means you can't drop things off 3 days before a hearing. It's not going to get scanned in administratively, and it's not going to make its way to me unless you deliver a second paper copy that's called a bench copy. So I have nothing that you're discussing in front of me.
Well, then
I thought that it just had to be filed by Friday. I must have misunderstood. I mean, last time I filed it on Monday before court and you had it then.
Sorry.
So I just must have misunderstood, but I did file something, so I'm not sure.
Okay. Let me chat with Mr. Gilbert. Mr. Gilbert, have you received the documents that she's referring to?
I got an email from her. Yeah.
Okay. What's your,
I was complaining about the time frame. Sorry. It wasn't important, but it was Penny's distracting me, and having this on 2 computers is distracting me. Their last hearing was Wednesday. She had to get the documents from the clerk of courts in another county, and then she dropped them off 2 days later, and she's getting chastised for not providing a bench copy. How the hell would she know that? Like, I wouldn't even know to do that. 3 days before, yeah, I dropped it off Friday. The hearing's not till the following Wednesday. That's plenty of time in my mind. And like, why did you schedule it a week out if she wasn't going to have time to do it? That just irritates me. That's all. Right? Yeah.
your position on this? She's
Right.
seeming to allude that you are in agreement
Button.
that your house is not a suitable place for the child right now.
It is now. I'm the only one staying at the house.
Say that again. I didn't catch it.
I'm the only one staying in the house, so it's a safe spot for the kid.
Okay. You're talking about, so Brenda is out of the house.
He's not staying in the house right now. No.
Okay. Well, I don't have anything in front of me.
I did give it to Keith, the guardian.
Okay, I'm gonna talk to Mr. Lawrence shortly. Anything else, Mr. Gilbert, you want me to know? Are you objecting to a change in the parenting plan at this point?
Yes, I object to it. I want it to stay exactly the same.
And as I see, you haven't had visitation now for quite some time because of these temporary orders. Is that right?
A very long time.
Okay. And I did receive your negative and review your negative UA results. So let me turn it over to Mr. Lawrence and get some input. It sounds like, Mr. Lawrence, you may be privy to documents I haven't seen, so I'll ask for a little input from you.
Yes, Your Honor, I did receive an email from Erin last week. And as she indicated, there was several documents in there. There was a statement by Brenda's current husband, or past husband, rather. There was a statement from Aaron and John's older son. And from what I gleaned out of the number of documents that she sent, is that there's complete chaos going on between Brenda and John in their home. And I would not recommend that the court allow visitation if the two of them are residing in the same home. John has undergone his drug and alcohol evaluation, but if the two were together, I would recommend that the court consider John undergoing a psychological evaluation with a parental risk component. If those two can't separate somehow, this is no environment for Max.
Mr. Gilbert, do you want to respond to that?
Yes, like I said, we're not living together. I was a father before I was a husband. I'm a dad. And I lost my parenting rights over a bunch of stuff that I proved. I don't do drugs. I don't do any of that stuff. So yes, we are not living together.
I'm looking to see, and I don't have confirmation of that, sir. I can certainly take your word here right now, but I don't have a declaration to that effect from any individual. I'm looking to see if we have an order on the adequate cause. Ms. Gilbert, have you filed a proposed order on the adequate cause decision?
The proposed parenting plan?
No, it's called an order on adequate cause.
Oh, I do not believe so.
Okay.
I do have something to say about him and Brenda being together if I have the opportunity sometime.
Go ahead.
Oh, just that he has I mean, this has happened multiple times where he says that him and Brenda are no longer together. And then they are together, unfortunately. And I do believe that this is just a lie, unfortunately, to get Max back. Anyways, yeah, I just do not believe that even if Brenda is not living there, which I do not believe that she's not, but if she isn't, I believe that would just be temporary. They very much have a history of breaking up and getting back together. So until things are final, I would not like Max to go there.
So here's what I'm going to do. I think this motion for adequate cause has been hanging out there way too long, and the court needs to make a ruling. Based on all of the evidence in the file, including input from Mr. Lawrence, I do believe the first ruling I'm making today is that there is adequate cause to change a parenting plan. This doesn't mean that I'm adopting any specific parenting plan right now. What it means is I believe there's enough evidence to move this forward to a trial, but maybe mediation first, on what the new parenting plan should look like. So after today's docket, I'm going to fill out what's called an order on adequate cause to change a parenting plan. I will find that Ms. Gilbert, who was initially the respondent in the underlying action, did make a motion for adequate cause decision, that today we did hold the adequate cause hearing, that I have jurisdiction over this case, and that I am finding that there is adequate cause to hold a full hearing or trial on the petition. The trial date will be set at a later date when we have further, when we're ready to get to that point. The other findings I'm going to put in this order are that for now, the prior judicial officer's temporary orders suspending visitation remain. Mr. Lawrence, what were the evaluations you were recommending? I wrote down parental risk assessment or component.
Right, yeah, a psychological evaluation with the parental risk component.
Okay, I am going to add that, Mr. Gilbert, to the order as an affirmative obligation that you will need to do. What I'm going to do after that is, and Mr. Lawrence, do you still have time with us on this case to remain as GAL?
I'm available to remain, however, my funds have run out.
I would like to keep you appointed to this now that I am finding adequate cause and moving this on to a hearing, trial, or mediation on changing the parenting plan. I will approve a request for additional time and money on this.
Okay.
Do you have a template order you could send over to me ex parte on that, or do you need the court to do it?
I don't have a template, Your Honor. I'm sorry.
Okay, let me just make a note for myself. And I'll get that done after docket as well when I do the adequate cause motion.
Your Honor, can I please at least just get the weekends with my kid?
Not right now, sir. I do want, what I'm going to do is set a review date. And we're going to set it 30 days out. And I would like you in that time, as best you can, certainly understanding it is difficult to get into medical providers. I would like you to get the psychological assessment with the parental risk assessment. I am also hopeful that by me approving some additional time and hours from the GAL, that we can kind of get to the bottom of what your living arrangement with Brenda is. I'm not convinced standing here right now that more likely than not, the two of you are permanently not residing together. So I am going to need some further input on that. So my hope is when we come back in 30 days, it'll be the review hearing. on kind of the immediate visitation issue and your compliance with the psychological evaluation. But then I would also like to address at that hearing whether you're ready to go on to the full hearing or trial on permanently changing the parent plan or not. Okay?
Okay.
So that's going to be, I'm looking at September 13 or 20. Mr. Lawrence, do you have a preference?
Your Honor, the parental risk assessment can take several months. So,
Oh, okay.
so the 20th would be preferable. I can address the living situation, and I can address whether or not Mr. Gilbert is attempting to set up an appointment, or he may even have an appointment, but it may be down the road.
Let's do that. I think that's a great idea, and thank you for that additional clarification. So let's set this to September 20th at 9 a.m. back on this docket for a review, for essentially a status review on those two issues. And then we will also talk about, I know Mr. Gilbert, you want to move this forward. We can talk about whether we're ready to get you guys sent on to, mediation or a trial. Okay.
Okay.
Any questions for me on this matter? Otherwise, I will get the adequate cause findings signed and filed. I'll get the additional time and money approved for the GAL, and then we'll see you back on September 20th.
Yeah, since Keith brought it up, or what? So where's the best spot to get these evaluations?
Your Honor, the only person that I know of locally that does that is Dr. Stephen Maharg at Northwest Psychological in Longview.
It's
Do
not
you have
even
any
writing
idea
it
what that
down.
costs?
It runs around $1,500. The last I heard, I don't know what his current rates are, but I can provide John with Dr. Maharg's contact information and so he can get started.
Okay. Thank you. I appreciate that. All right. Ms. Gilbert, Mr. Gilbert, you are free to log off.
Thank you.
I believe.
So the cost of that assessment, I think someone told me was close to $1,000. So he's probably going to have a fit when he sees that. The other thing, getting into doctors is really taking forever. I had a referral to a cardiologist last week, and I called him. They scheduled me for January 2024. I was like, and if I have a heart attack between now and then, just go to the ER. Okay, sure, great. Love healthcare in the US. So I looked it up, and hair follicle test, just FYI, because it took him 4 months to get the hair follicle test. Why? So many drugs show up on the hair follicle test within 1 week of usage. However, they stay in a standard 1.5-inch sample taken near the root for just around 90 days. So, you take it a little bit further than that if you want to make sure it's not there, and that kind of fits with the time frame it took him to get that hair follicle test done, just, hypothetically and all. Oh, wrong one. I clicked this.
Mr. Gilbert, you're in one of the iPad booths.
Yes, I am.
Okay, and do we have Aaron Gilbert with us?
Yep, I'm on here.
Okay. So this is 1830023808. I believe Mr. Lawrence. Oh, there you are. Good morning. Sorry, I have 2 pages of Zoom screen, so I'm not seeing everyone right away.
Yeah.
Okay. So we did, last time we were together, we talked about, I had issued an order granting or finding adequate cause. I think that we also had issued an order needing more investigation from the GAL before we moved forward with a new parenting plan or trial on the new parenting plan. So I guess first, maybe Mr. Lawrence, I'll check in with you and see where we're at.
Well, Your Honor, as you are aware, there was an allegation and a police investigation earlier this summer whereby John and his current wife, Brenda, got into a heated argument, and she alleged that John had assaulted her. He was not charged with that. And there were a lot of issues, and Brenda suffers from some mental health issues. And the question was whether or not it was safe for Max to be there while the two of them were fighting. And John had indicated that Brenda was no longer living at the residence. And so on September the 12th, I made an unannounced home visit, and Mr. Gilbert met me out in the front yard and indicated that Brenda was indeed living there with him now. And that she is undergoing
Busted.
mental health counseling and I believe drug and alcohol counseling as well. The court had ordered Mr. Gilbert to get a psychological evaluation with a parental risk component, and I provided him with the contact information for Dr. Stephen Maharg at Northwest Psychological. And that's pretty much where we're at this point, because I haven't heard whether Mr. Gilbert has an appointment for that evaluation.
Okay. Thank you, Mr. Lawrence. I appreciate that. Mr. Gilbert, what can you tell me about the court-appointed psychological evaluation?
They're months out, and right now we just got out of fire season. Money's tight. We've been shut down, and I know looking outside, you wouldn't believe it, but we've been on a level 2 all summer long, level 3, and shut down. So with that,
Money was
I would like
tight
to
in
know
February.
what evaluation could be next. Like you said, this cases are going on forever. I was court ordered to do the hair test and a drug evaluation, clear back in like January. I don't do drugs. I never have. Everything came back negative. The hair sample, the evaluation, nothing needed, everything else. And now all of a sudden, this evaluation. So after this evaluation, what is next?
So that I'm not addressing that, what's in front of me today is whether you have complied with my August 16th ruling that you obtain a psychological evaluation with parental risk assessment. So are you letting me know that for whatever reason, and I certainly understand there are reasons, are you telling me that that has not been scheduled yet?
It has not been scheduled due to financial difficulties.
Okay. When do you think you'll be able to get that scheduled?
I don't know. How long does the supervised visitations? I get those, and that's another $400 a month. It costs me $100 for 2 hours to see my kid. When does that end?
So, sir, you're answering a lot of my questions with questions of your own. That is that's not my role in these proceedings. My role is to ask you the questions. So the question I'm asking you is, when do you think you will be able to get the psychological evaluation scheduled?
As soon as we get back to work and stuff, I will try.
Okay, so can you estimate the length of time that?
Is it just me, or does he not seem to connect the fact that his action is what is going to get his kid back? It's like he feels like him doing what the court is telling him to do has nothing to do with him getting his kid back. Like, they're two separate things. Like, just freaking do it. What is wrong with you?
That may take, and I'm asking so that I can get you back in court as quickly as possible once you do have that done.
I guess a few weeks.
Okay, let me turn to Ms. Gilbert. So Ms. Gilbert, at this time, the only thing I can do obviously is keep our bench orders regarding suspension of in-person visitation in effect. So I'm not going to be making any changes. Everything's going to remain
Oh.
status quo so Mr. Gilbert can get that done. What would be your request for timing to come back to court, or do you have a preference?
I know that is
I don't
fascinating
have a
at first.
preference.
Laughed.
I mean, I don't understand why he can't schedule it if they're months out and then, or, get it on scheduled now.
Yeah.
If it's months out, he doesn't need the money now to schedule it. So
You could put the money in the piggy
Okay.
bank and save
So
up.
what I'm going to do
Can I
is,
please ask something, Your Honor?
Mr. Gilbert, go ahead. I didn't catch your statement.
Can I please ask? So with the hair follicle test that was ordered, that evaluation that was ordered, those come back negative. If I do this evaluation and it comes back, I have no issues, what could be ordered next?
Mr. Gilbert, what I'm telling you is, I don't have a crystal ball. I don't know what that evaluation is going to show us. It's been recommended because there are enough allegations that your child may have witnessed violence in your home. So our overriding goal is always what is in the best interest of your child. To that end, we've asked for this evaluation. Once I've had a chance to review that and the GAL has had a chance to review that, we will come back and talk about it and where we go from there. But that really is the next step. So what I'm going to do, sir, is I'm going to set this for review of compliance with that evaluation 4 weeks. I don't think it's going to happen before then. I'm pessimistic it will happen by then, but I don't want you all to be in limbo. So I'm going to set this to Wednesday, October 25th at 9 a.m. back on this family law A docket. Does that work for the parties?
yes, for me.
Okay. Mr. Lawrence
Yes, it works for me, Your Honor.
Those earrings.
and Mr. Gilbert?
Yes, it works for me. But when I talked to the GL, he said Max didn't witness anything at the house. So he never did see no violence. There was nothing there. Parenting plan proves that. On the dates that the police reports were done, the parenting plan proves that I didn't have Max. I didn't take Max to my house when I had him.
Okay. All right, Mr. Gilbert, what I am talking about right now is you getting the psychological evaluation before we can move forward. Hopefully you can get that done, or at least a scheduled date by October 25th. And we'll see you all back October 25th at 9 a.m. Okay?
Thank you.
All right,
Thank
thank
you,
you all.
I'm gonna make that stop. Okay. So in 2-3 weeks, we have another update. But until then, that's what we have. So maybe we should start like a poll whether he gets it done or not. He frustrates me to all get out because right? If he's not capable of putting 2 and 2 together to say, oh, if I do this, then this will happen, then I don't think he's capable of caring for a teenager. I think he was postponing the drug test personally because, the timing's just a little over 90 days. Takes 90 days to get out of your hair. I don't know. Suspicious? Is that what they call it? Thank you for hanging out with me. I am working on editing the day 4 of the Boy in a Box trial. It's a lot to edit. There's more ring video, and I keep forgetting my camera's up here now, not down here. And it's not easy to listen to. So I apologize for not getting that out Saturday night like I promised, but I ended up with a migraine, and that's just not good for editing slamming doors and screaming kids. So I'm working on it, and I will probably have that out tomorrow for you so we can do another live and talk about it. And then I found another really crazy case that maybe we can cover after that. So I hope everybody has a wonderful Sunday night. Go check out Georgia Peach's channel. Go check out Debbie's channel. You can probably click on their names and it'll take you there. Hey, Brooklyn mom, you know what you do? We've solved this problem. So you put it on the TV and then you get your phone out and you put your phone on mute. And then you can chat on your phone while you're watching on the big TV. I can't watch it on a little phone, or I need it on the 65 inch, 70 inch. I don't know how big it is. I got a massive TV in my bedroom. So that's what you need. What's it called? Kerman and Peach. Send Debbie a link and she'll post it next time when she remembers, like as often as she remembers to post a link to her own channel. But hey, you know, I appreciate you all. We expect nothing less. Yes, no court Monday, so I will try and get you some stuff out to keep you occupied tomorrow. I was watching Judge Simpson's streams at 2 o'clock in the morning when I woke up and couldn't go back to sleep, because every morning between 1 and 2 o'clock I wake up. It's like there's some internal alarm clock that will not turn off, and I have tried very hard to turn it off. And I found a lot of just, yeah. Crazy. So I'm going to try and put some of those together and I'll keep you guys occupied. Have a wonderful evening. I will talk to you all soon. Take care.